Good morning or good afternoon to wherever you are joining us from today. My name is Dan Johnson. I'm the Director of Marketing and Customer Experience here at myHRcounsel, and welcome to this week's edition of the myHR Minute. As a reminder, everyone who attends will receive a follow-up email tomorrow. You'll receive the slide deck, the HRCI credit, the SHRM recertification credit, as well as a recording of this webinar if you need to hop off for whatever reason. This week we'll be covering the future of non-competes and the proposed changes at the federal level. And we are joined by our senior attorney, Britt Waterman. Thank you, Britt.
Thanks, Dan. So like Dan said, today we will be talking about some proposed changes to non-competes, restrictive covenant agreements at the federal level, some things that are not laws but may become law as we move forward into the new year. Let's see, that's me. I'm, as Dan said, I'm Britt Waterman. I'm a senior attorney here. So this proposed ban on non-competes comes from the Federal Trade Commission. So the Federal Trade Commission is an independent federal agency. It is not part of the executive, legislative, or judicial branch as we know them, but we still have to follow its rules and we still get in trouble if we break them. So this is not the House and the Senate passing a law. This is not President Biden telling people what to do. Remember the OSHA vaccine mandate? So OSHA is part of the Department of Labor. The Department of Labor is part of Biden's cabinet, the executive branch. So that OSHA vaccine mandate, that was Biden telling employers what to do. This is not that. This is an independent government agency. So the FTC is how multi-level marketing schemes get busted, or why Whole Foods can't buy up all its competitors. It's because the FTC says no. So it's not a member of the three branches, but Congress has given it power to tell companies what they can and can't do. The members of the FTC are appointed by the president. So there is a political slant to the issues that the FTC focuses on, or how they rule on issues, who they decide to go after based on the makeup of the commission, whether it's a majority of Democrat or Republican appointees. Right now it is a majority of Democrat appointees. So we can go to the next slide. So here's how the FTC got involved. Again, you may have heard that you can't have a monopoly in the United States. That comes out of the Fair Trade Commission Act. A monopoly would eliminate fair competition, which would eliminate consumer choice. So consumer choice is an American value that we want to protect. The FTC Act seeks to ban any unfair competition to protect that consumer choice above all else. So what the proposed rule actually is, the proposed rule actually is much stronger than any state law currently in effect. There are state laws that have restrictions on non-compete agreements. Some apply to low-wage workers. Some do strongly restrict non-compete agreements. What the proposed rule is that it would be illegal for an employer to enter into or attempt to enter into a non-compete with a worker, maintain a non-compete, or represent to a worker that the worker is subject to a non-compete. So it would essentially wipe out non-competes completely. This doesn't agree to restrictions during employment. You can still have an agreement not to compete while the employee is employed with you, that is still okay. You can still prohibit moonlighting or working for a competitor while they're still employed with you. This applies only to agreements not to compete after the separation of employment. So who is affected by this? This applies to both employees and independent contractor. It applies to everyone who works for an organization. It does not apply to a franchisee in the context of a franchisee-franchisor relationship. So in that relationship, a non-compete would still be valid. So the proposed rule would require individual notice to employers would have to provide individual notice to all current and former workers who have signed non-competes, telling them that they are invalid. If this rule is passed, and this does come into effect, the FTC will publish a model notice that employers can use to send to current and former workers. So the FTC will let you know, hey, this is what you have to say to your workers in order to comply with the law. You won't be left wondering, what do we say? How do we say it? The FTC is going to guide you through the process. If they pass the rule and they make the non-competes illegal at the federal level, they're going to walk you through what you need to know. Other restrictive covenants. So this is a big concern for my clients is, what about, does this make this the Wild West and our employees can do whatever they want after they separate from us, and they can go and tell their new employers all of our trade secrets and steal all of our customers and all of our clients and bring them over to their new employees? Well, it's not that, it doesn't go that far, and you do still have some control over what happens after separation. So this is banning non-competes, which is an agreement not to work, not to accept employment with a competitor or accept employment in the same field in which the employee is working. That is what is banned. Agreements will be banned. It is not in effect now. It is just the rule is being contemplated. So that is what will be banned, is agreements saying you will not accept employment with another insurance broker within 50 miles, or you will not work in the paint and wallpaper sales industry for a year. Those are the kinds of agreements that would be banned under the new rule. Agreements prohibiting the solicitation of customers, clients, anti-poaching rules, the agreements prohibiting encouraging other employees to leave your company and join the former employee at their new company. These agreements will probably still be okay, as long as they are not so broad as to have the effect of preventing an employee from seeking or accepting other employment. So some of these anti-solicitation agreements prohibiting solicitation of customers or clients I've seen have been so overbroad where it prohibits employees after separation from talking to any customers, past, present, or future, anyone who might want to purchase a similar product within 100 miles, anybody who might think about using our services, you can't solicit. Well, that has the effect of preventing an employee from seeking or accepting other employment if they can't talk to a client who might think about buying your kind of product. That's so broad as to have the effect of preventing an employee from seeking other employment. But if the agreement is no soliciting our past or present customers, that's still going to be okay. So the proposed rule provides for a functional test that's going to test the agreement that you want to have the employee sign, and what is the function of the test? Is the function of the test to protect your goodwill, or is the function of the test to keep the employee out of the labor market? And so that's going to be the test of the proposed rule, to see whether it is okay under the proposed ban or not okay. So next step. So the FTC has published the notice of proposed rulemaking that gets this potential ban off the ground. There is a period of time when the public can submit comments. So until March 10th, 2023, you can submit comments to the FTC and say, no, don't do this, you'll destroy my business, or I think this is fantastic. More employers need to be restricted from these non-competes. They're terrible for us. They prevent us from recruiting top talent. Whatever side of the fence you're on, certain and all of my clients, can see both sides of the issue, whether they're having problems with their employees being picked off by competitors who can offer a more competitive compensation package, or whether they are having a hard time recruiting because all of the top talent is bound by a non-compete. So all of my clients kind of fall on one side of the issue or the other. It just depends on the labor market in their area. So if you have an opinion on this, you do have the ability to submit comments on the rule until March 10th. And the FTC is actually going to review all of the comments they receive. They could make changes to the proposed rule that we've been discussing, and then they will issue a final rule. Now, what happens with the final rule is that they publish it in the Federal Register, which is where agency rules get published, and that makes them go into effect. If a final rule is published, you'll have 180 days from the date of publication to comply. So you essentially have 6 months to retract all your non-competes that are in effect and stop having employees sign them. Could this be like we've seen with the OSHA mandate or the Department of Education issuing student loan forgiveness? Although, like I said, this is a little different. This is not coming from President Biden. This is an independent agency. Could the Supreme Court, could somebody challenge this rule in federal court, and could it go before the Supreme Court? Yes, it could. Yes, it could take that path. Nothing is ever final until it gets to that point. But if it is published in the Federal Register, you're going to want to comply with that. You're not going to want to sit around and see what happens. You would want to be putting that into effect. So potential signs that this has for success. In July 2021, President Biden did sign an executive order making this an issue for the federal government to focus on. One day before the proposed rule was issued, the FTC did take action against 3 companies that they claim to have imposed illegal non-competes. So non-competes are on their radar. They have been paying attention. They have been taking action. And the proposed rule was issued 3-1 over the opposition of Commissioner Christine Wilson, who is the sole remaining Republican appointee on the commission. So if you look at the makeup of the commission and how the commissioners felt on the proposed rule, that may be a window into how they're going to feel on the final rule. We will just have to wait and see. So thank you for participating in my HR Minute. If you have any questions, if you are a client, you can open a ticket. We'd be happy to provide you with more information. If you are not a client, you can certainly go to myHRcounsel.com and look at our subscription packages if you'd like to become a client and receive information on things like non-competes, how non-competes affect your business, what we can look at non-competes that people you're recruiting have signed, or ones that you're looking at having employees sign, things like that. We can help you draft those. Certainly, we look at these every day, and our experienced HR and employment law attorneys have a lot of knowledge at this. If you have any questions, you can also email info@myHRcounsel.com. We'd be happy to discuss anything we've talked about here today, or help give you information about our subscription packages. And if you're a client, like I said, open a ticket. We'd be happy to help you with legal advice on any legal issue that is affecting your company. So thank you for participating today.